Eduzi Top Lawyer NPA boss or lawyer appear Dankwa, director of legal affairs Emma United Party almost share, especially Eduzi Top Lawyer was say MP before when I move fail Chama Wontumi. Now lawyer appear Dankwa company was say conversation I said Nana Akufo-Addo bam because Nana Akufo-Addo the mounted platform because the Chama Wontumi is not involved in illegal mining in any way. As at the time I know Kasano or said that Konta mining firm is not doing galamsey. Abusiafo. Now, Eduzi Top Lawyer say case in the way NPP for see handle no from. In fact, money mukro catch them. 2019 NPP for na amend them rano. I say ude okon session mo be without the authorization of the sector minister. Abusiafo yemfa nko chef ya say not less than 15 years. Or say NPP for the year. The case na nkasa kwampo time starting na NPP time. Eti mo ankasa na mo start Chama Wontumi case na fe e ba ne say na na ko chef ya say a mo be yagu MDC so. I say we political imprisonment. Then the lawyer appear down because there be political imprisonment. How do you term this as political imprisonment when a competent court of jurisdiction a convict will be also on the money? Then you jano. Now I think 32 minutes. But men skip starting from Eduzi Top Lawyer to appear down. Muka say we are na fifi buafu so show so MPP no at a point of bum then a clash see. No more control, no more twaso. My person will be tea. I'm gonna see no one hunter say right here on Soka Show. Me patch subscribe. We have bell notification icon or button on video. Drop your answer. Feel free to leave your comment in the comment section. Or share link in for fro and you be a share. Lel Flower Green Clay Solutions Center. We go so moto answer fro. It's a open clinic company. I'm about to prep presses. You fee office or check bank institution. And a per year you remember how I come away and I'm Miss Row. Frewatika crabby but you never trying to pull at the amount different numbers in the good screen so ya chili kwa just ufra kana obakumasa just traffic light no o try up won say for sabroseto so 1-2 as you pay won say ebe kan do free kumasa na kwa cry won sabe nkum so very natural backups about 2 menstrual pains and abdominal pains I say what me can we intend them FDA approve e man na use nyina so edi ho adanse e nso kotobi abusiafo yenko tie submission no me enjoy a pan to the number 3 years I also enjoy Eduzi Top Lawyer lawyer appear Dankwa United Party and of course Fifi Boa for MPP.
Okay, so the success or otherwise on appeal would largely be based on the grounds formulated, the nature of the evidence that were put before the trial court. And the first principle that we must all agree is that appeal is by way of rehearing. So the 3 appellate courts are put in the place of the trial judge. So they will be going through the trial as though they were the court of first instance. But just that in this case, they don't have the benefit of evaluating demeanors and all of those things. They will be looking purely on the record. Yeah. Then based on that, they will be making, so like the lawyers will say, appeal is by way of rehearing. So they will be put in the place of the trial court. But you see, I've heard a lot of comments, particularly on this Wontumi trial. And I think that we need to do a bit more of critical thinking on these issues. You see, look, I think the NPP as a political party failed Wontumi. And they are hiding that failure by trying to shift the goalposts to other people. Why do I say so? The first time that this Wontumi matter became a matter of public conversation was by the Minister for Lands and Natural Resources under the NPP, who first raised the issue that Akonta mining is engaged in a forest without the necessary authorization. That should have been a red flag for the NPP. This is your original chairman. This is what he does. It is your collective responsibility to ensure that he does it right. You failed him. And instead of taking responsibility for that failure, you are looking for judges. You are looking for people to blame. No. Look, if you recall, this same Samra boy and Tano, Akonta mining and Wontumi in particular, if you call the 2013 incident, where he accused that the previous Mahama administration, officers of state had destroyed his mining concession and others. When the NPP came to power, he decided to issue a writ to challenge that process. The matter went before my Lord Justice Ajay Frimpong. At that time, he was a justice of the Court of Appeal. Now he's a Supreme Court judge. When he evaluated the entire evidence, he came to the conclusion that whatever the state agencies did at that time was lawfully carried out. It didn't end there. 2023, Samates, you know them.
Yeah, very well.
You know Samates. Wontumi went on to Samates forestry concession and started mining. Samates issued a writ against Wontumi for trespass onto their concession.
In a civil
matter. I'm just giving you a pattern of conduct. The matter went before the High Court judge at 2nd D. I still remember, I think I have the case. If you look, when the matter went before the High Court judge in 2nd D, Samates won against Wontumi. And the High Court judge in 2023, not 2026 or 2025, the High Court judge came to the conclusion that Wontumi had trespassed on Samates' concession and were engaged in illegal mining.
Engaged in illegal mining?
Yes. I just want to read portions of the judgment for you.
Samates versus Akunta mining.
Yes. So this is the decision in the High Court of Justice, Western Region, held at the 2nd D on the 19th day of May, 2023, before her ladyship, Efia Edu Amankwa, Samates Timber and Plywood Company Limited versus Akunta Mining Services. This is the decision of the High Court. And if you look at the 16-page judgment, he said, even though the defendant has acquired the mining right to subject Samurai Boy through the mining lease agreement between the government of Ghana and the defendant, blah, 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 that mining lease is invalid. In the circumstance, the defendant counterclaim is dismissed. That is Wontumi.
But Eduzi, not to interrupt.
Look, I'm coming. Please, I'm coming. At that time, Wontumi claimed that he should be given damages for all based on that counterclaim. The High Court judge found him and invalidated the supposed lease. This is Samates. Then came the decision of Akunta Mining versus the Minister for Interior, Defense, among others. That again, the court found that Akunta Mining had engaged in illegal mining.
This is just a question.
But you see,
it's a question for you
please
to clarify.
Go ahead. Please go ahead.
Yes. So I have not read this judgment.
Please, I will share with you later.
Based on what you just said, I'm only asking the question. Is it also not the case that Wontumi went on or Akunta Mining, because the company is a distinct personality from Wontumi as an individual? Were they not also claiming that indeed a lease had been given to them and the lease covered that portion of land, so for which reason he did not just enter on that plot of land as though he just decided to do so without a lease? Is that not what his contention was at the time?
See, at that time, the concession was that Wontumi had failed to comply with the laws of this country for whatever he's doing. Mining is regulated. You can't just wake up and say, I'm going to mine. Yeah. So the point I am making is that they had been consistent. In fact, they had been...
I was only asking the question. Did he have a lease for that portion of land?
The court said it was invalid for whatever
but he had a lease.
No, but the point is that...
he was not just somebody who had decided to go and then disregard the law.
I am making this point. I am making this point because, you see, 2019, my Lord Justice Ajay Frimpong had ruled against him, the same mining activity. 2023, the same High Court. So I am making the point that even prior to this judgment, there were subsisting judgments of the high courts of this country against the company that you people knew, but took a certain posturing. Sometimes I have the feeling that you guys felt you will never lose power.
Yeah.
And therefore, there was a certain level of impunity with which you handle some of these undertakings. Look, I remember when Anado appeared before the Catholic Bishop Conference in Koforidua and made the point that as far as he is concerned, as at the time you were speaking, Wontumi was not engaged in galamsey, that for me should have been a red flag. Look, this morning I heard you make the point that, listen, the basis on which this judgment came, circumstantial, there was no direct evidence and all of those things. You are a lawyer to be, so you are a lawyer, I'm a lawyer. The first thing we are taught in the law of evidence class is that there are two things every lawyer looks for: the burden of proof and the burden of persuasion. These two things. We know that in criminal trial, the burden of proof is on the prosecution and is proved beyond reasonable doubt. But we also do know that within this burden, there is also a burden of persuasion.
Yeah.
That burden of persuasion is not fixed. It oscillates.
Yeah, it can shift,
It moves from parties to parties.
At which point, or the instance of
okay,
the
so
trial
the point is that in a trial like this case, when you make a positive assertion, the burden is on you to prove. That's persuasion. So when, for instance, you make the claim that I brought Henry Okun onto the concession only for reclamation, who bears that burden? Counsel. Oh, my brother.
but so he,
because you see,
proved
at that
that
point,
he brought the gentleman for a specific
and that is
duty.
what that is why I asked that. So the burden,
That's what he said.
So the burden was.
So if you disagree,
wait.
I'll allow you to proceed. If you disagree, he says that, well, I brought him to come and do reclamation. If you disagree, the burden is on you.
No. First of all, no.
How?
No, the burden doesn't shift.
It is you who is alleging that the person was there for different purpose.
in order for us to reduce the interjection, let's
I don't intend to do that.
You see,
Counsel, you have 2 minutes
I will
more
finish
to-
with that. You see, in this particular case, you came and said, in fact, if you look at, and let me read Chairman Wontumi's paragraph 8 of his witness statement that he gave when he appeared before the court. I just want to read that portion, the paragraph 8, if you permit me. And like we always say, nothing convicts a man faster than his own words.
Yeah.
Or
And this was under cross-examination?
no, the witness statement that he offered. And this is why he said, paragraph 8. I wish to state clearly and unambiguously that the permission I granted to Mr. Henry Okun was strictly and exclusively for the purpose of land reclamation. Specifically, the planting of cocoa seedlings on the already mined and degraded portions of A3 concession. I did not at any time grant Henry Okun permission to conduct, undertake, or carry any mining operation or to extract minerals from A3 concession. The permission I granted was limited solely to reclamation activities on the mine out portion. That's your bare assertion, bare words. Now the man, Henry Okun, you are saying that it shifts to him. So the man now comes and says, Chairman, this is not what we agreed to do. What we agreed to do was that, one, you are not giving me any money for reclamation. I will mine. And the portion where I went on to were on the unmined. You only reclaim that which had already been mined.
Yeah.
So you cannot be talking about reclamation when the place you asked me to go is the unmined portion. That testimony was never controverted.
Yeah.
That testimony under cross-examination was never controverted by Wontumi's lawyers.
So it's
under cross-examination.
So it gives a cause for.
So it leaves it hanging. So what it means is that even if it's on oath by oath,
no cross-examination.
Yes,
on appeal, it's just the record. That is that. So that is why I'm making the point that when you go on appeal, that is the only thing. Then now the man says that, Chairman, you know reclamation is expensive. Did you give me any money for reclamation? No, because you wanted me to mine to pay. So where can pay arrangement? All these things are in the testimony. That is why when he brought the Western Regional
Minister,
the former Western Regional Minister, as his prosecution witness, under cross-examination, a simple question was put to him. Were you there? What would be his answer? Definitely not. You were just the chairman of RECSEC. So the point I am making is that if you read throughout the case point by point, you will notice that there was a simple case of failure. Look, this is what is it Ochridakun?
Joe Ochridakun
Kwabna. This is why he said, in my capacity as the chairman of the Western Regional Security Council, I presided over the council's meeting, coordinated the council's responses to security threats and challenges in the region. I had direct access to and familiarity with the official records, correspondence, and proceedings. I was personally involved in the council deliberation of matters relating to illegal mining in the Western region, which was one of the most significant security and environmental challenges. This is what he said. So if you look at all of this, it comes to the conclusion that either there was a failure in strategy or there was most of the things were just an afterthought. I make this point mindful of the fact that the proof is proved beyond reasonable doubt.
Precisely.
But the rule of law has always been not fanciful doubt. That is the rule of law. The rule of law is beyond reasonable doubt, not fanciful doubt. So if you decide that you dwell on fanciful doubt, the court will resolve the matters most importantly against you. But I just want to read this and so that we can. Look, PW2, under cross-examination, this is what he says.
Let's talk about it.
Yes, I will. During the time that you started mining in their contact concession, did A1 ever come to the site to supervise your operations? Then answer, no, my lady. A1 did not. In fact, indeed, first accused himself told the court that he never visited the mine site after tasking PW2 to carry out land reclamation on that land. So at all material time, there was some uniformity, admission that at least Henry Okum came onto the land through the invitation by Wontumi. So what are we talking about? Where you are now, excuse my language.
He was never there.
Please, hold on.
To see that indeed illegal mining was taking place.
I'm coming
so
to you.
He could say that yes, he was not aware of that.
I'm wrapping up on this. You see, where you are now, if you have a concession, can me, Eduzi, a bystander, just walk onto the concession?
You want me to answer?
Yes.
Of course, he gave the person a permission, and the permission was for a specific activity, reclamation, and that's what it is.
Do you know that it was Akonta Mining that engaged the Western Regional Security Council to ensure that the activities of Henry Okum was protected? Do you know that?
And his activity was reclamation.
For security. Broad security for reclamation. Okay.
Well, you may have your doubts, but then it does not.
No, it's a question.
If there is any doubt in a criminal trial, it must not go against the accused.
No, you resolve doubt in favor of the accused, but not fanciful doubt.
This is not fanciful.
Is it not a possibility that one ground of appeal for the lawyers for Wontumi for this very appeal will be that there's been over-reliance on the testimony or the evidence of PW2?
Interesting. When you said, is there a possibility? I remembered one of our favorite days in Faculty of Law when a mate of mine asked, is there a possibility, so and so, and Professor Kumado said, dismissed it and actually gave her a name. Madam Possible. Yes.
Okay, so Mr. Possible.
I still call that she's my sister, Mrs. Asari. Good morning, and I wish her a lovely day, whoever she's currently at work. But when he said the possible, I just remembered that. You see, I don't know. Before that, I agree on. I stand on all forces with the position of my brother Eduzi. I think the argument is legally sound, and I do not have to rehash a lot of things he has said. But I find it very interesting the position the NPP, first of all, has taken. I don't know why they keep on rehashing assignment. Have they read the charges and have they considered the terms of Section 14 of the Minerals and Mining Act under which he was charged? When you read that section, I know that the heading is assignment, but the prohibition or the law there is clear that you cannot assign, you cannot transfer, you cannot mortgage, you cannot create any encumbrance, you cannot allow anybody to deal with your concession without the express consent of the minister, which consent should not be unreasonably withheld. I think it's pretty clear there. And so I don't know why they keep on talking about assignment, because the Section 41 there is not just about assignment, it also includes allowing somebody to deal with your concession without the express consent of the minister.
In
also,
writing.
I think it is also quite clear that I think that under Section 106, any contravention of the Minerals Act is an offense, constitutes an offense. Not so. So I think that position is also clear. And also, I think if there's one fact that we cannot dispute, is the fact that there was illegal mining activity beyond the contravention of Section 14 happening on Wontumi's concession. Yeah, there was because I think the evidence is pretty clear that Ukum was engaging in mining activities on Wontumi's concession.
They both agreed.
Yeah, I think that is pretty clear, and for me, I think it is fundamentally clear. As the NPP failed Wontumi, but most importantly, they failed Ghana. The bigger issue that they failed Ghana, because it's not a worry that, in spite of the terms of Article 257 of our Constitution, which creates in the President of Ghana, he's a trustee over the properties of this country. And then, one of the fundamental duties of a trustee, first of all, is to protect the property. That you must prevent stealing of the property. Because Galamsey is essentially stealing. And in spite of all that, and in spite of the clear words of his minister in charge of mining, because like Eduzi rightly said, this was not activity that the president had not been notified of.
Yes.
We all knew that the minister then raised issues about what was happening at Samaboy. We all know, not so specifically. But even if I have to expand, we also all know that per Professor Frimpong Boateng's report, way back in 2021, the president knew clearly about the activities going on and about the serious and tacit involvement of Akuta mining.
But that's outside this instant case.
Now, what I'm saying is that go and read the Prof. Frimpong Boateng's report again. He made
they are irrelevant to this instant case.
What I'm saying is, I'm saying that beyond whether appeal or no appeal, what I'm saying is that if there's one fact which is not under dispute, is the fact that Galamsey activities was going on the land the subject matter of this case. It's clear. You understand? If there's nothing that is in dispute, the fact that the president knew or ought to know, because the minister had given him, his minister in charge, had given him notice.
And this is something that he put his presidency on
the line for. Now,
that generally is for Galamsey across Ghana.
Particularly that Galamsey was happening there. The RECSEC. So, per our governance architecture, we have a regional security, you understand? And really, they are the agents of the president. Really, all the RECSEC across the country are agents of the president. So when they know of something going on, the president can be presumed to also be in the know. Now, the evidence, like my brother Eduzi made reference to, show that Wontumi or the RECSEC were meant to be protecting Ukum. So the RECSEC throughout that period, they didn't see if indeed the purpose for granting that protection was for the planting of coconut trees.
For reclamation.
And he said
is it not possible that the RECSEC could also be brought in based on request.
But you see, Roland, your question,
them.
Roland's question is to the effect that reclamation. But you all know that reclamation is a mining support service and can only be conducted by somebody registered to undertake. So on what basis would you invite somebody who has no such registration to conduct?
Why was the Attorney General not interested in all these matters? But the interest was just with
Henry Okum, you see that's the mistake you guys make. Please. I think I need to correct this misconception. The impression has been created by the NPP that the AG targeted Wontumi. There were series of accused persons. Then one person went to the AG and said, Attorney General, no. He said, Attorney General, I want a plea.
But
that is what formed the basis.
So
it's
you're
not
saying
AG.
that the plea options were available for all of them?
All of them. Wontumi just felt that he could defend his action. But Henry said no. In fact, he even said when the NPP did free Wontumi, they excluded him from. Nobody said free Henry. That was when he said, the way things are going, I may be left in the loop. So let me approach the Attorney General. That is what is on record.
That's what one to be. Anyway, so the point I was making with the RegSec issue was that if indeed we all agree,
and I'm coming, that is not possible that you are reclaiming land.
You are still doing possible. But the point is that what it means is that
because we do not have evidence.
I said that there's no dispute.
That you need security to reclaim land.
But that is not the focus of what I'm saying. So take your time and finish. What I'm saying is that
Eduzi is telling us that they went there to see.
It is my time. Stop this. Stop this. I'm speaking. Then stop this.
You know what?
Where from this one?
You are distorting his thought.
No.
You see, what I'm saying is, if there's no dispute as the fact that galamsey or illegal mining actually happened on the land beyond the reclamation, then it means that the RegSec knew about that. They knew because they were there to protect, and they saw illegal mining happening. They knew. Now the point is, what steps did they take? So and then by inference, the president ought to know. Yeah, because if RegSec were there, they were protecting. They saw illegal mining happening. They saw galamsey happening. So beyond whether or not there was reclamation, they actually saw galamsey happening. The president saw galamsey happening.
The president?
You're not listening to what I'm saying. RegSec, the original RegSec are actually the agents of the president.
And in fact, there was a letter. There was a letter from Akunta Mane signed by Wontumi to the RegSec.
So
it's on record.
So the RegSec knew that galamsey was happening. So by inference, the president knew because the RegSec are the agents of the president. The president
Why do you like bringing the president?
Yeah, because he is the one we created the trust in. He is the one we created the trust in. You understand? Then the president, with all this information, or His Excellency Nana Akufo-Addo, with all this information available to him, had the audacity to stand in front of Ghanaians, because you see, per the terms of Article 1 of our Constitution, sovereign power belongs to us. You see, sovereign power belongs to the people. So the president is there and he's exercising power that we have given him. So he's accountable to us. You understand? And in spite of that, and in spite of the fact that we had created in him a trust, and in spite of the fact that the president had information, you understand? Based on the letters given to from Akunta to RegSec. Based on the fact that RegSec were there, the president stood in front of Ghanaians and lied. He lied. He told us that so far as he was concerned, Akunta Mane was not involved in galamsey. He lied. And you see, should accountability, you see, we should look at the terms of accountability, because accountability, probity and accountability is one of the bedrocks of this democracy. And the philosophy of deterrence, as was copiously espoused in this case, and was given as one of the reasons why Wontumi was granted 20 years. In my view, we should look at whether or not we cannot hold persons that we've held trust over the resources of this country who have negligently and criminally sat down and allowed the property, the trust property, to be stolen, blatantly to be stolen. You understand? Whether or not beyond, as in, we shouldn't have proper accountability on such persons. And indeed, because you see, we should look at that. that whether or not there cannot be any basis for hauling the president. Listen, I'm asking Ghanaians a question. Whether or not we cannot look at hauling the president and have criminal accountability, hold him criminally liable for this blatant, what's it called, a crime done against Ghana. And you see, and the NPP have the temerity to come and sit on air and raise very, I don't use the word useless. I'm struggling not to use the word useless because take all
way.
So you take all the arguments they are making in respect of. First of all, they claim Wontumi is a political prisoner. Come on, Wontumi is a political prisoner. How can you make that when Wontumi has been convicted clearly under a term of a law that by inference we the people of Ghana took upon ourselves to protect?
Not only that, the amendment to the Minerals and Mining Act was done in 2019 and assented to by President Anado.
Why do you people keep referring to?
Was it for political prisoners?
Two. Then they talk about it's not a direct evidence, it's circumstantial evidence. Jesus Christ. Our Evidence Act recognizes circumstantial evidence as a credible evidence in our
since 1965.
And the principle is simply the circumstances. The better one used to prove the surrounding
facts from facts.
And the question is, when you put all these circumstances together, does it lead you to one irresistible conclusion? Now the point is that Wontumi per his own evidence said, listen, I allowed this guy to enter onto my land. Then he interestingly made an assertion that listen.
But he said I didn't tell him to go and.
So he says that, and that was when my brother was saying, and he won't understand. So beyond his saying that was when there was a burden on him. That's what the judge asked. That did you even have a payment agreement? So there was no evidence really about the agreement between Wontumi and himself. Two, the Okum guy then gives a different evidence. He says that listen, what you allowed me to do, what you tagged me to do, was to go and mine. Use the process of that mine to reclaim. Now, based on evidence that was adduced before court, can you reasonably say that it led to any other conclusion? When clearly there was no evidence to the effect that I was going to pay him for this very expensive venture. You see, there are serious questions that Ghanaians ought to have, serious debates that need to be done. First of all, I'm saying that the first one is whether or not we should not have a situation where the president can be held accountable for issues where he sat down and breached the fundamental terms of his trust. And two, the question Ghanaians should be asking, and it's a serious question I've already been saying, is NPP a party, this current NPP, that has an ambition towards granting proper service, or they are there to use this vehicle to pursue their parochial political agenda? Because in how they have...
How do you draw those conclusions when in 2016 they were given massive votes to rule this country as well?
And so they were given a mandate. Now, how did they use that mandate? You understand? You were given a mandate, and one of the most critical mandates, you understand, per our constitution, was a mandate that says that you are supposed to hold our mineral resources in trust. And one of the requirements where a trust has been created on you is that one, you protect the trust property. That you are held to be in a position of fiduciary in respect of that trust property. So when the NPP, when the president they sponsored, sat down, in spite of all the information available to him, beyond him not taking any action to prevent the stealing of the trust property, also had the cockroach audacity to stand in front of us Ghanaians, his sovereign. He had the cockroach audacity to stand in front of us and tell us a blatant lie. The question is, we ought to ask ourselves this question. This NPP party, do they have the interest of Ghana at heart? Or this NPP party, do they believe that the reason why you should pursue power so that you serve the people, that indeed we ought to have a discussion whether or not accountability, criminal accountability, should not be extended on the president in whom a trust has been given, when really he suddenly criminally allowed that trust to be breached. These are questions that Ghanaians ought to ask themselves.
Okay. I think I love the submission. Submission manager. The program Nessie. It be the big man himself, Nana Janta, Mobile and Kawadun Sokatwa show. Me patch on subscribe. We are not turning your bell notification icon. Ebasa de mo di shabu biem. Bye bye.